For those of you who are advocates trying to defend against breath test readings or trying to introduce them into evidence, those of you who are judges, I think it's important that you hear this definition of clear and convincing evidence. This was something you want to know because this was a judicial disciplinary case that the Supreme Court utilized to define clear and convincing evidence. And I'd like you to listen to it carefully. Now, unfortunately, a word that they use repeatedly in this definition is the word conviction. It just means a firmly held conclusion. It does not mean proof beyond a reasonable doubt. So try to put that out of your mind. I hate when there's a standard here and they keep talking about conviction, but they mean a firmly held conclusion. Here's the definition, and you decide whether you don't think that this is at least as high as proof beyond a reasonable doubt, or maybe even higher. In order for you to introduce into evidence the results of an Alcotest test of a defendant, you have to believe that that machine was in proper working order and that the operator was properly qualified and that the test was completed according to procedure properly by this standard. Clear and convincing evidence is that which produces in the mind of the trier of fact a firm belief or conviction, as to the truth of the allegation sought to be established. Evidence so clear, so direct, so weighty, so convincing as to enable the fact finder to come to a clear conviction without hesitancy of the precise facts in issue. Now that quote is in your materials and you'll find it in it. It's from In Re Seaman, which was ironically a case involving some sexual allegations.
It's true.
It's true. I mean, he was predestined. This is his at birth. But listen to the middle part of that again. A firm belief or conviction as to the truth of the allegation sought to be established. Evidence so clear, so direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy. So at the end, when the arguments are made, if you say, is a hesitancy. That's not by clear and convincing evidence. I have to tell you the truth, in the criminal cases, if the judge gave me the definition, it said I could choose between charging the jury on the definition of proof beyond a reasonable doubt or proof of clear and convincing evidence. As a defense attorney, I'd want clear and convincing evidence charged because it's that strong. I'm not sure that there's a viable difference between the two.